Yeah. 2. Yeah. Aye. I'm jacking the beat, you calling the cops, the yapping is cheap, I call you the ops, the rapping is heating, it's all cause of pop, you get a leak for the ball, get a drop, feel like I'm wrong when I double it back, cause I'm making it harder to catch that, but I covered the ticket, I call you to visit, you tipping and hit up the cash app, baby girl been round for it, yeah, in the old days, I was stuck in old ways, never really trying to flip the old page, young man tripping at an old age, thinking I was flicking, had a low wage, led the bro days, then a slow praise, thinking it'd be different, it would gon' change, then it really didn't, it's a cold game, yeah, ayy, all I really wanted was the money in the pocket, got over money, but the money ain't the topic, like Bill Doe and the money gotta stop it, kid need food and the whip need juice, I'ma get these views when
Why they party? I'm in here grinding. Money I'm stacking. Why they rock diamonds? I can't relate to them, ain't my shit common. I set a goal for me 2 or 3 commas. 7 figures, 8 figures to 9 figures. On a slow pace to get rich quick. Same time we just think different. Cause when you make it, it hit different.
What it do, y'all? It's your partner Dale back in the saddle again, guys, for another edition of the Countermove Podcast, guys. Thank you so much for your time. And if it's your first time, guys, welcome. If you like what you hear and I give you value, share. And again, this is where we kind of take an issue, whether it be political, social, economic, even financial or business-wise. We kind of look at a situational issue. We kind of unpack it, lean in, reason together, infuse wisdom into the situation, and then prescribe the right solution. So welcome again to another edition of the Countermove Podcast. Again, share, and subscribe. Guys, on this one, this one is going to be an interesting one because of the fact that I need all my legal egos on this one. Because of the fact that if you guys have known, I believe last week or earlier this week, there was a Supreme Court hearing on the President Donald Trump Colorado ballot case. If you guys didn't know that the Colorado Supreme Court basically decreed that President Trump was disqualified from the ballot. It was just a decree. And they said because he committed insurrection. The problem with that is that he has not been convicted or even accused or charged with insurrection at all. They just declared it. And they said based on their interpretation, basically, of what he said on the ellipse. And so, of course, that caused a little bit of a constitutional crisis because it's the first time this has ever been done in U.S. history that a state Supreme Court made a unilateral decision and disqualified a candidate from the ballot. And so, of course, President Donald Trump's team appealed it to the Supreme Court. The Supreme Court actually has taken the case. And guys, I don't know if you guys listened to a lot of the exchange between the President Trump's attorneys and also the state of Colorado attorneys. They allowed for, which is normal, audio to be presented as a present as they are talking through this whole thing. And guys, it got really, 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 really good. It was really kind of a class on really the Constitution. Some attorneys have said that Trump's attorneys did a terrible job, as well as the Colorado's attorneys did a terrible job. There's been some commentary on the performance of these legal counsels, but I'm not here to talk about that. I'm here to actually talk about and to listen to and respond to what's actually went on in the Supreme Court. So, guys, before we do that, let's take a look at the Constitution, the 14th Amendment, Section 3. This is exactly what the argument was over. It was over this section, guys. So let's go ahead and look at it real quickly and read it together, right? Here we go. This is Section 3, 14th Amendment, Section 3 of the Constitution. It says, disqualification of holding office. No person shall be a senator or representative in Congress or elector of president and vice president and hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to enemies thereof. But Congress may by a vote of 2/3 of each house remove such disability. So the argument, guys, is over this section, right? The Colorado Supreme Court has came and said that um, basically President Trump committed insurrection, right? This section right here, the insurrection, this clause right here. Boom. Way to go to insurrection. They go insurrection. They're saying that he actually committed insurrection. The problem with that is he was never charged at all with insurrection or has been convicted. They just declared that he had committed insurrection. Now, I believe it was I think it was a 5-panel judges on the Colorado Supreme Court. I believe 3 voted yes, 2 voted no. And I may be wrong on the numbers as far as the amount of justices on the Colorado Supreme Court, so forgive me if I am, but it was more yays than nays when it came to this decree. The problem with that is President Trump has never been convicted or even charged with insurrection. I don't think anyone at all has been charged in anything concerning January the 6th has been charged with anything with insurrection. Nothing. And so they just really declared that he had committed insurrection. That was kind of interesting. So, of course, President Trump's team actually appealed it to the Supreme Court. So let's read it over one more time, guys, for the folk in the back row. Thank you guys for being here. I see you, CC. I see you, Destin. Thank you guys for being here. Appreciate you. Let's go back to it real quickly here, right? And let's read this one more time. And I really want to focus on this section right here. It says, no person shall be a senator or representative in Congress. So that, that section's talking about Congress, senator or representative, or elector of president. Okay. A president can elect himself, right? It has to be electors to do that. All right. And vice president. So they covered the electors for that office, right? Or hold any office, civil or military, under the United States or under any state who having previously taken an oath as a member of Congress, again, very distinct, or as an officer of the United States. Officer. The argument is over this word officer when it comes to this section, because what Colorado is saying is they're saying that he's an officer, and you will hear this in the oral arguments. The president is an officer of the United States. That's actually incorrect, because the president is not an officer. The president is an actual branch. There's 3 branches of government. You have the executive branch, which is the office of the president. The president himself is the branch. Okay? All the cabinets and all these other subdivisions are just they flow from the president. The president himself is the executive branch. Alone, he alone, not the vice president. The president is. Then you have the legislative branch, which is the House and the Senate. And then you also have the judicial branch, which is, of course, the courts, and really the Supreme Court, because these other courts are not even mentioned in the Constitution. The Supreme Court is. So it's very clear that the president himself is different from the other branches, because the other branches have multiple members, right? You have multiple Supreme Justices. Okay, that's the judicial branch. You have multiple houses in the legislative branch, with multiple members. That's the legislative branch. The executive branch is in one person, the president, not the vice president. Only the president is that branch. It's not an office. It is he alone. He alone is the president by himself. That is clear here. So the so as you can see, it's clear right here what they're talking about, right? So you're going to hear language around the word officer and electors. Officer and electors, what you're going to hear. Electors and officer. This is where you're going to see a lot of the arguments coming from. So I'm going to need all my legal eagles here, guys, to kind of chime in real quickly. It's not boring. It's interesting because I think that we should know this type of stuff. This type of stuff, when it comes up, guys, we should be knowing this. We should be experts here as well also, or have access to experts that can explain this to us. So some folks may say, "Yeah, this is boring." To me, it's not, because the decisions affect your lives, right? So if you're okay with someone making a decision that affects your life and that decision runs your life, cool. That's not me. That's not me. If that makes sense. So guys, let's go to the first judge, right? And we're going to go to Judge Ketanji, Justice Ketanji Jackson, right? And she really kind of surprised me a little bit, guys, because she was kind of going in a little bit on this, but you're going to hear her go in, guys, and she sounds the alarm on the Trump ballot case. She sounds the alarm. And just watch what she says. It was a very interesting exchange. Here we go. Oh, 1 second, guys. My bad, guys. Here we go. Let's get to it. This is Justice Jackson. Here we go.
Justice Jackson?
So when I asked you earlier about the uniformity concern and the troubling potential disuniformity of having different states enforce Section 3 with respect to presidential elections, you seem to point to history in a certain way.
Okay.
You said, I think, that the framers actually envisioned states enforcing Section 3, at least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections as opposed?
So what she does here, guys, real quickly here, is she begins to ask a very good question concerning this. It's extremely good. She goes right to that first section of the Constitution, talking about the electors of the president and vice president. She asked a very clear and distinct question. Listen to the exchange. Here we go.
Opposed to focusing on the presidency.
Well, 2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access
and anything
else.
Okay.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there.
Yes.
And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
This came up in the...
Excellent. That was so good. Man, she went right to that first section, right to that first sentence talking about electors. And she brilliantly says that every position when it comes to the section is actually detailed in Amendment, 14th Amendment, Section 3. She said that there was nothing at all about the president at all. And she even gave a unpacked it more when she said how they can bar that a charismatic person, as this person was saying, is through the electors. Oh, this was good. Let's keep going, guys. Here we go.
In the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No, I'm not going to that. So let me just say, so your point is that there's no ambiguity with having a list and not having president in it, with having a history that suggests that they were really focused on local concerns in the South, with this conversation where the legislators actually discussed what looked like an ambiguity. You're saying there is no ambiguity in Section 3?
Let me take the point specifically about electors and senators, if I might, because I think that's important.
Okay.
Presidential electors were not covered because they don't hold an office. They vote. And this
No, I'm talking about the barred office part of this.
Exactly.
She's clear.
So barred offices, if you want to include everybody, first you have to specify presidential electors because they're not offices, so they wouldn't fall under any office.
That's not what this says.
Senators and representatives don't hold office either. The Constitution tells us that under the incompatibility clause and refers to them as holding seats, not offices.
What?
And so you want to make sure that there's no doubt that senators and representatives are covered. Given that the Constitution suggests otherwise, you have to include them. The Constitution says the presidency holds an office, as do members of this court. And so other high offices, the president, vice president, members of this court.
All right, let me ask you, I appreciate that argument.
Man, she's killing them.
If we think that the states can't enforce this provision for whatever reason in this context, in the presidential context, what happens next in this case? I mean, is it done?
If this court concludes that Colorado did not have the authority to exclude President Trump from the presidential ballot on procedural grounds, I think this case would be done, but I think it could come back with a vengeance because ultimately members of Congress may have to make the determination after a presidential election if President Trump wins about whether or not he's disqualified from office and whether to count votes cast for him under the Electoral Count Reform Act. So President Trump himself urges this court in the first few pages of his brief to resolve the issues on the merits, and we think that the court should do so as well.
And there's no federal litigation, you would say?
Well, that's correct, because there is no federal procedure for deciding these issues, short of a criminal prosecution.
Thank you.
Wow, man, I got to give it to Justice Jackson. Man, she eviscerated that thing. Woo! My God, that was such a healthy exchange. And she really focused on that first sentence about electors. And you begin to see how you have this, the Colorado attorney began to kind of talk about a different train of thought there. But she was like, no, we're going to stay on this here. She was very clear about the president not being detailed in Section 3. Electors, Congress, senators, every other name was in there, but the president and the vice president. Matter of fact, at the bottom of Section 3, it talks about that's to be 2/3 vote of both houses, which is the House and the Senate. She killed that thing. My God, phenomenal presentation. Now, guys, let's go over to Justice Kavanaugh. Justice Kavanaugh came in a little bit as well. He was talking about raised concerns about the Colorado disenfranchising voters. That's what he wanted to focus on concerning his section. Let me get to him real quickly here. Here we go. All right, here we go. Justice Kavanaugh. He focused on that whole thing, and this was a healthy exchange as well also. And notice how I'm going back and forth. I'm going to a liberal judge and a conservative judge. And we're getting both points of views to see how they're arguing this from the text of Section 3 of the 14th Amendment. Here we go. Let's see what's going down here. Here we go. Boom. Here we go.
Justice Kavanaugh?
The concerns of some question have been how the states having such power over a national office. Other questions about the different states having different standards of proof.
Okay.
And they seem underscored by this case, at least the dissenting opinion below. Justice Sotomayor said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom, end quote. And then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote.
Wow.
Now, I don't know whether I agree or not. I'm not going to take a position on that. But the fact that someone's complaining not about the bottom line conclusion, but about the very processes that were used in the state would seem to, and that would be permitted, seems to underscore the concerns that have been raised about state power. Just wanted to give you a chance to address that because that was powerful language. Again, not disagreeing about the conclusion, but about the very fairness of the process.
Yes, Your Honor, but that language was, with respect to Justice Sotomayor, just not correct. President Trump had a 5-day trial in this case. He had the opportunity to call any witnesses that he wanted. He had the opportunity to cross-examine our witnesses. He had the opportunity to testify if he wanted to testify. And of course, the process was expedited because ballot access decisions are always on a fast schedule. But in this whole case, from the trial court all the way up to this court, President Trump has never identified a single process other than expert depositions that he wanted to have that he didn't get. He had the opportunity for fact witness depositions. He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title.
So you're hearing Justice Kavanaugh focus on the insurrection part. Here we go.
Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, it says shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about 6 years before Section 3. It wasn't meant as implementing legislation related to Section 3. And I would emphasize that by the time that Section 3 was ratified, most Confederates had already received criminal pardons.
I guess the question is a little bit different, which is if the concern you have, which I understand, is that insurrectionists should not be able to hold federal office. There is a tool to ensure that that does not happen, namely federal prosecution of insurrectionists. And if convicted, Congress made clear you are automatically barred from holding a federal office. That tool exists, you agree, and could be used, but has not, could be used against someone who committed insurrection. You agree with that?
So Justice Kavanaugh is saying that if your concern is about insurrection, he said there's already a tool in your toolbox that you can actually use and just charge him with insurrection if he's committed these acts. So he's like, why haven't you done that? Let's see the exchange that he actually has with his attorney concerning this subject. Here we go.
That's absolutely right, Your Honor. But I would just make the point that the framers of Section 3 clearly understood that criminal prosecutions weren't sufficient because oftentimes insurrectionists go unpunished, as was the case in the Civil War, and that the least we can do is impose a civil disqualification penalty so that even if we don't have the stomach to throw someone in jail.
Well, they had the quo warranto provision that was in effect then from 1870 until 1948, but then obviously that dropped out and hasn't been seen as necessary since then. Last question, in trying to figure out what Section 3 means, and to the extent it's elusive language or vague language, What about the idea that we should think about democracy,
Okay.
think about the right of the people to elect candidates of their choice,
Okay.
of letting the people decide, because your position has the effect of disenfranchising
Good point.
Voters to a significant degree.
Good point.
And should that be something, does that come in when we think about should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
I'd like to make 3 points on that, Justice Kavanaugh. The first is that constitutional safeguards are for the purpose of safeguarding our democracy, not just for the next election cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way. The framers of Section 3 knew from painful experience that those who had violently broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve. President Trump can go ask Congress to give him amnesty by a 2/3 vote. But unless he does that, our Constitution protects us from insurrectionists. And third, this case illustrates the danger of refusing to apply Section 3 as written. Because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him. And the Constitution doesn't require that he be given another chance.
Wow. So what's happening there? What's happening there, guys, is that was Justice Kavanaugh. He really focused on the disenfranchising of voters as well as the word insurrection. He said that when it came to the word of insurrection, there is a tool already that can be applied, but unfortunately, the attorneys or Colorado's not using that at all concerning charging President Trump with insurrection if he's guilty of this, so to speak. Charging them and then getting them convicted, but they haven't did that at all. Period. So he said there's already a remedy on the balance on the books for you to actually do, and they won't do it. And then number two, he talked about, okay, if we allow this to happen, isn't this effectively disenfranchising voters? And look at how the attorney for the Colorado side actually began to answer the question. He smuggled in that Trump is already guilty of insurrection, which he's not. And so with that smuggling in, he then began to unpack an argument of we have to protect this because he smuggled in his argument that he's guilty. But there's been no conviction at all, and there's been no indictment at all. Period. No one on January 6th has been convicted or even charged with insurrection. Not one person. That includes President Donald Trump. So interesting exchange, guys. Man, now let's go to Justice Sotomayor. She asked Trump's lawyers to pin down the principal argument on Section 3 in Ballot case. So Sotomayor, what she does is she goes into which I believe is a healthy exchange to Trump's attorneys to ask him some questions, guys. So let's go to her real quickly and see what she actually says, and then we can respond from there. Here we go.
Mayor? I just want to pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States.
Okay.
Your principal argument is that the president is not an officer of the United States.
Okay, officer.
Correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal, that it's not Section 3 that's at issue, but Thornton and others as to whether Section 3 can be enforced by states against the president?
that would extend to every presidential candidate, not
Exactly,
just our
not just
client.
Gotcha. So now you saw Justice Sotomayor focus on the presidency itself, because the argument of it is you have the Colorado side is saying that a president is an officer of the United States, and you have the conservative side said no, he himself is the branch, which textually the conservative side is actually correct. The president himself is the branch. He's not an officer. Those under him are officers. The president himself is the branch. Everything flows from him. Everything flows from him. Everything does, guys. So you saw what she focused on. She focused on the presidency itself, as far as the function of or what it is when it comes to the branch of government, right? So, man, good exchange. Now let's go to Amy Coney Barrett. Justice Barrett, she came in and she pressured the Colorado lawyer in the Trump ballot case. And to be honest with you, she kind of went at him a little bit, not so much as Justice Jackson, but she went at him. And let's see what actually happens. Here we go.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
Three points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record.
Okay.
And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Yes, it is.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief.
Yeah.
He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
So what's happening there is that attorney on the Colorado side is basically saying our evidence is what he said on the ellipse on January 6th. That's the evidence. And so he's trying to make a legal argument, but when he's pushed on the legal side from a disenfranchising type of scenario, saying how is it legal for one state to decide who's going to be president, he then backs back into, I believe, Section 2, which talks about the state legislatures selecting the electors, which then marries right into Section 3, which is that first section about the electors of president. So he's going back and forth there because, to be honest with you, he has no legal leg to stand on because he's smuggling in a guilty of insurrection. But there's been no indictment and no conviction of insurrection. Again, nobody at all on January the 6th has been convicted or even charged with insurrection. Nobody. That includes President Trump. And so you see him going back and forth. I mean, a great healthy exchange on there, but then he backs back in and says, hey, just look at the videotape. Look at his words. Look at his words. We can do that all day long, but a videotape is evidence. But you come in making a legal case. He's kind of going back and forth, but hey, it's all good, guys. And the guys, we got one more. Thanks for sticking with me. The lawyer defends Trump from disqualification to Justice Thomas and Roberts. This is the last one. This was a good, healthy one as well, guys, because of the fact that I like the fact that, to be honest with you, Justice Thomas and Roberts asking the questions to President Trump's attorneys. So let's see what happens. Here we go.
Mr. Mitchell, would you, you didn't spend much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement the disqualification in Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point. But if this court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Counsel,
Going back to the Congress, okay.
What if somebody came into a state Secretary of State's office and said, I took the oath specified in Section 3, I participated in an insurrection, and I want to be on the ballot? Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits, because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office.
Interesting.
And then see whether Congress lifts that disability after the election. This happened frequently in the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each house would determine for itself whether to seat that elected insurrectionist, because each house is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding, essentially, that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
Well, even though it's pretty unlikely, or at least would be
Pretty
difficult for an individual who says, you know, I am an insurrectionist and I had taken the oath, that would require 2/3 of votes in Congress, right?
Correct.
Well, this is a pretty unlikely scenario.
It may be unlikely, but no Secretary of State is permitted to predict the likelihood of a waiver, because in doing so, they're adding a new qualification to the ability to run for Congress. And the proper analogy, Mr. Chief Justice, is to state residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even if somebody comes in and says, I'm a resident of the Secretary of State's office in Illinois, and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when the election is held? So if the candidate makes clear, perhaps through a sworn declaration or through his own statements, that he has no intention of relocating to that state before Election Day, then the Secretary of State would be enforcing an extant constitutional qualification rather than enforcing a new state-imposed qualification. And that's the key under term limits. Is the state in any way altering the criteria for a federal office, either for Congress or for the presidency? And in this situation, the Colorado Supreme Court is going slightly beyond what Section 3 requires, because Section 3, on its face, bans an insurrectionist only from holding office.
Guys, that was a great exchange there, guys. Because of the fact that you saw President Trump, and I think his turn did a really good job, was really and also Justice really focused on the powers of the state, saying that a state cannot add an additional criteria for a candidate to qualify for a federal office or a federal position, so to speak, right? And they really talked about, you know, a Congress or Senate, and also really the presidency as well, because of the fact that that they don't have that type of authority from the Constitution. No, the only authority the state actually has is to the state legislature to pick their electors for the presidency. That is it. That's all they have. They don't have any decision-making power on criteria for a federal position or federal office. I mean, it was real clear, and he really laid that thing out well. Here, all right, guys. Here is my reaction real quickly. And thank you guys for your time. I know it's a lot of legalese, but it is what it is. It was good to hear. Now, what's my reaction? Number one, I believe that the Supreme Court on this case will rule 9-0 or 8-1. Most likely 9-0. Really, because in the entire exchange, and that whole exchange is about 2 hours plus, right? The whole exchange is about 2 hours plus. In that whole exchange, what the justices were doing, they were saying, okay, what authority does the state actually have, right? What authority does the state actually have? And then number two, the textual language of the U.S. Constitution, 14th Amendment, Section 3. Whether they were liberal or conservative, they were focusing on those two things. And also that third one is, hey, if we grant this, doesn't this disenfranchise voters? And is it wise to actually have one state have the authority to decide who the president of the United States would actually be? They eviscerated the Colorado lawyer side. That was it. So, number one, not one person has been charged with insurrection. Nobody, from President Trump on down to anybody that's been convicted of any crimes that actually happened on January 6th. No one has been either indicted or convicted of insurrection. Not one person. Not one. But so you can't just decree somebody is guilty of insurrection without going through the process. That's the reason why Justice Kavanaugh was saying there are remedies already in place on the books for you to conclude on insurrection. Why won't you use them? Because they can't prove it in court. They cannot. In a fair court. They cannot at all. They can't. And that's why the Colorado lawyer began to point toward the verbiage that President Trump actually had on the ellipse on that day. And so look at his verbiage. We can listen to that all day long, but that doesn't qualify for insurrection at all. If that's the case, why haven't you guys used that as evidence to charge him for insurrection? If you're saying that's the evidence, why haven't you used it yet? Why haven't you? That's what Justice Kavanaugh was saying. He was saying that you have a tool in your toolbox. Why haven't you used it? The reason why, guys, is because they can't prove it because it didn't exist. It's simple. It is simple. I believe President Trump attorneys could have did a better job, but they did okay. And to be honest with you, I gotta give up for the Colorado attorney. He actually argued. He really argued. I don't agree at all with any of his arguments at all. That didn't make any sense at all. He was doing a lot of stretching, going from the Constitution, Section 3, to the state electors here. Everywhere he moved, there was a legal remedy for his movement, and he could answer those questions in front of the Supreme Court. It was a legal apologetics course. What it is, I believe it was important for us guys to kind of lean in and listen to those exchanges, so that you can grow in wisdom, knowledge, understanding. So that if you're ever in a situation to where you need to know the law, you know how to process these things, and also hire the right people and ask them the right questions as well. Also, does that make some sense, guys? Whenever I actually hire on an attorney to be a counsel for a state for me, I ask them qualifying questions to make sure that they're competent in what they're saying that they're competent in. It's very simple. And it was very evident that these justices, they were competent on the Constitution, which is 14th Amendment, Section 3. They knew it, and they knew the history behind it as well. Justice Jackson went in. She went in. And it was a healthy, phenomenal exchange between her and the Colorado attorney. And I also liked Justice Thomas and Justice Roberts asking the question, kind of really pushing Trump's attorneys as well. Healthy exchange, guys. Again, my prediction, guys, is going to be either 9-0, 8-1. Who is the one going to be? Maybe Sotomayor. Maybe. But in order for you to be able to conclude that he's because of this insurrection without him being indicted or convicted of insurrection, you have to really stretch things. Really stretch things. So that's all I have for today, guys, man. What's the counter move, guys? Very simple. Very simple, guys. I always say peep it, sweep it, and keep it, guys. Here's my counter move for you guys. Hey, I say examine your current situation. Very simple, guys. Hey, if there's a topic that you're not wise in, don't be afraid to, number one, seek wise counsel, and number two, read a book. Go out and search for the answer. Right? Go out and search for the answer. And so that's why I said, what's your strategy moving forward? If your strategy is to be on Instagram, or social media, although I thank you for listening to me and devoting your time with me today, if you spend the lion's share of your time on social media and you're not renewing this with your mind, you're going to get deceived. It's very simple. I know that may have been boring, but that was a healthy exchange because the Supreme Court are making decisions that can affect your life. Your life. You better know what's going on, guys. And I would say, what's your strategy moving forward? What is going to move forward, guys? What's your strategy moving forward? Sweep it, guys. What's your strategy moving forward? What you going to do? Just sit there and chill or what? And then, of course, keep it. I always say, start thinking generationally. If your solution begins and ends with you, you have already lost. You will be deceived. Who was it? Dr. Miles Monroe said this here. He said, the most wealthiest place in the world is a cemetery. Because so much wealth has been buried that has not been released to the world because someone did not know how to unleash the gift to the world. That's the wealthiest place in the world, the cemetery. Don't be that person that takes the gifts and talents that you've been blessed with, right? And take it and not pass it on to the second and third generation, but take it to the grave with you. Don't be that person. Be a world changer, right? Be a disruptor. Do that, guys. Once you've done that, guys, your whole world will actually begin to turn around. Again, I always say, peep it, sweep it, and keep it. Very simple, guys. Simple, guys. Well, guys, thank you for your time. Oh, real quickly, guys, we do have, Julius, what's going on, baby? How you doing, Julius, man? Good to see you, man. We do have, guys, a sponsor for your partner growing a little bit, man. So thank the Lord on that one. It's American Rounds, guys. Here's a little commercial for them. Here we go.
I'm Majors. I'm the CEO of American Rounds. We are in Pell City, Alabama at Fresh Value grocery store installing the first ever automated retail machine for ammunition. The stores were really the inspiration for it. I mean, they knew their customer base and they came to us and thought this would be a really good opportunity for their customer base. There's a lot of hunting community here in Pell City and thought that their customers would love an opportunity to be able to buy ammunition here at the store.
We're super excited to offer, what we think is the first ammo kiosk. We're always looking for ways to give our customer another reason to come visit our stores. Anything that we can do to help them make their shopping trips easier based on the feedback that we've gotten just from customers today. They are so excited about us having the ammo kiosk.
We're getting ammo!
One of the ways we're changing the landscape of ammunition sales is to make it more available. Being able to move into a place like a grocery store, supermarket makes it a lot more available to the public. But we're taking a different approach to it. Traditionally, ammunition is sold at outdoor type stores, your sporting goods stores, and it just sits on a shelf. It's very accessible. Because of that, there's a high rate of theft. But with our machines, as you can see here, we have a very secure automated retail machine. We're able to age verify. We scan a driver's license. It then takes 360 facial recognition for the purchase and matches it to the ID. So the machines really provide an opportunity for safe, affordable, and available ammunition sales.
There is no doubt that foot traffic will increase based on the feedback that we've gotten. And again, we're super excited not only to have it here, but in other locations in Fresh Value as well.
We're really excited about where we're going. We are going to continue to expand here in Alabama. We have a machine slated to go into Oklahoma, Louisiana, Texas. So over the next year, we're looking forward to, seeing these roll out all throughout the South and the Southeast.
Guys, that's American Rounds. Guys, American Rounds, they are revolutionizing ammo sales, guys, in a very safe and secure and convenient way, guys. So, man, I actually invested in the company, guys. I am a partner of that company, but they wanted to sponsor our podcast, guys. Hey, man, I had a good interview with the CEO, Grant Majors, as well. We got to chop it up a little bit about this as well, guys. So visit anything American Rounds, guys. Go to @American Rounds or go to AmericanRounds.com. It's an AI-powered ammo vending machine, guys. It's a game changer, guys. But guys, man, thank you so much for your time, man. I see your destiny. Thank you so much. Appreciate you. God bless you as well. God bless you as well, guys. Guys, thank you so much for blessing me with your time. It's been almost an hour. But guys, you know how I end it every single time. Before you leave, and while you can, You see that thing, baby. Take that damn picture and give it to your mom and them and holler at your partner. God bless you guys. See you next week. Peace. Long live the king.